Members, the meeting is now called to order. First, confirmation minutes of last meeting. The Secretary has not received any proposed amendments from members. So, shall we confirm the minutes, please? Okay, then the minutes are confirmed. Today, we are to meet the deputations and the administration. So, shall we invite them into the room first? Those attending the Bills Committee meeting today are Ms. Selina Yan, Deputy Secretary for Financial Services and Treasury, and her colleagues, Ms. Ada Chan, and then Mr. Howard Lee, Executive Director of the HKMA, his colleagues, Mr. Darrell Hall and Ms. Polly Lee, and then the Executive Director of the SFC, Mr. Keith Loy, his colleagues, Mr. Rico Leung and Ms. Daphne Du. Welcome to you all.
我謹代表法案委員會呢，係歡迎各個團體嘅代表出席今次嘅會議。就住2013年證券及期貨修訂條例嘅草案呢，係發表意見嘅。我亦都歡迎政府當局同埋證監會嘅代表呢出席會議。各位需要嘅時候呢，如果係需要即時傳譯呢，都可以帶上呢個耳筒然後呢就按照座位上面已經顯示嘅語言嘅頻道呢，嚟到選擇，好嘛？今日出席呢個會議嘅一共有8個團體嘅代表係會發表佢哋嘅意見嘅。另外亦都有7個代表呢係
7 other submissions have been received. First of all, I will invite the representatives of the deputations to speak first, and each will have 4 minutes. After the representatives have spoken, then I will ask the administration and also the representatives of the SFC to respond. Afterwards, members may put questions to the administration, the SFC, and also the HKMA, and also the representatives of the deputations. Now, unless you don't want to disclose your submissions will be put on the web page of the Legislative Council. Up till now, we have not received any indication from any deputation that his or her submission should be kept confidential. So we have put your views on the Internet. And if you have not given your written submission or your speaking notes to us, and if you do have, then please give them to us after the meeting. And if I may remind you that what you've said here and also what you have written to us will not be covered by the Electoral Powers and Privileges Ordinance. Okay, let us start. If I may invite the representative of the Citigroup Markets Asia Limited to speak first. Mr. Leung. I am the person in charge of the tech division of the Clifford Chance, and I have to declare interest because Mr. Francis Edwards is a partner of Clifford Chance. Do other members want to declare any interest? If not, then I have to declare interest because I'm a non-executive director of the SFC. All right, let us start. Mr. William Ching of the Citigroup Markets Asia Limited. You have 4 minutes. Good afternoon, Mr. Chairman. Good afternoon, ladies and gentlemen. Thank you very much for inviting the Citigroup to attend this important meeting. We are part of the participants of the financial markets in Hong Kong. We, the Citigroup, support the reform proposals of the HKMA and SFC. I think you still remember the impact of the financial tsunami on the financial markets and also the enhancement of regulatory standards. We will do our best to assist the Bills Committee, the HKMA and SFC to formulate suitable regulatory regime so as to enhance the stability of the OTC derivative market and also enhance its fluidity or liquidity. We hope that the bill can be passed successfully so as to maintain Hong Kong's leading role as a financial center. Thank you. Mr. Ching's other view has been put in writing, and you may refer to that as well. Next is Ms. Pearl Wai. Good afternoon, Chairman, and good afternoon, ladies and gentlemen. Thank you very much for inviting Citibank to attend today's meeting, and I agree with what's said by Mr. Ching. The Citibank Group supports the government's attempt to legislate on regulating OTC derivatives. Our views have been submitted to the Bills Committee through Clifford Chance. We don't have anything further to add. But let me stress that we'd like to thank the administration, the SFC, HKMA for giving the opportunity to Citibank Group to participate in this important market reform exercise. Thank you. Next is the immediate past president, Mr. Jim of the Hong Kong Society of Financial Analysts.
This is supportive to the new provisions regarding the reporting, clearing, and trading obligations. Having that said, we also emphasize we have to have a balance between the practical and the implementation, of which we believe that the implementation transitional time should be reasonable in view of the infrastructure building. And in that sense, we also suggest to have a pilot scheme with the large corporation before the official implementation. We also think that the bill should not only looking at the product class, but also the underlying securities, given the complexity of the transaction. On top of that, we welcome the central counterparts clearing establishment. But we also want to highlight that the nature of derivatives basically make it difficult to transact all of them in the exchange. So in that case, we believe we have to look at the flexibility, whether the centralized counterparty facility will be able to support the multiple venue transaction of the OTC derivatives. So we are supportive to the bill in general. Thank you so much, Chairman.
The next is a partner of Clifford Chance, Mr. Edwards, please.
Thank you for inviting us to the meeting today. I'm presenting on behalf of a group of international financial institutions, all of whom are interested stakeholders in the Hong Kong financial markets and are dedicated to Hong Kong's success. The group is committed to helping the Bills Committee, the HKMA and the SFC develop an appropriate and proportionate regulatory framework that enhances the stability and liquidity of the OTC derivatives market and maintains Hong Kong's status as a premier international financial centre. There are three key messages I would like to deliver on behalf of the group today. The first is the importance of a two-stage process to develop the regulatory framework for Hong Kong's OTC derivatives market. Second is the importance for Hong Kong to develop a regulatory regime which is internationally aligned with other major jurisdictions. And the third is the importance of ongoing dialogue and market consultation during the rulemaking process. Starting with the first point, the group fully supports the two-stage process provided for under the bill, which lays down a broad regulatory framework and empowers the HKMA and SFC to create detailed rules for the mandatory obligations in the form of subsidiary legislation. The approach is consistent with the approach that has been adopted in various other jurisdictions, including the United States, the European Union, Singapore and Australia. Following the Financial Stability Board report published this month, we expect that Hong Kong will be keen to adopt legislation promptly to comply with its G20 commitments, and the group is very supportive of helping Hong Kong to do this. Second, allowing detailed rules to be set out at the subsidiary legislation level will facilitate international alignment of Hong Kong's rules with those of other jurisdictions. This is because it will allow the HKMA and the SFC to continue their active dialogue with other international regulators, of which they are a key part, in order to implement rules which are internationally consistent. The importance of international alignment is recognised by the G20 and international regulators, and we strongly encourage the continuing efforts by HKMA and SFC to achieve this. Conflicting, duplicative or inconsistent rules for trading derivatives as between Hong Kong and other jurisdictions could result in the restricting of the ability of Hong Kong and foreign market participants to enter into OTC derivatives transactions with each other, or could make Hong Kong uncompetitive internationally through inefficiencies or unnecessary costs or barriers. This would have serious ramifications for the liquidity and efficiency of the OTC derivatives market in Hong Kong and could stifle the development of the renminbi derivatives market. Furthermore, inconsistencies in the standards imposed could lead to needlessly onerous requirements for market participants faced with multiple regulatory standards. This could hamper the ability of Hong Kong corporations to carry out hedging activity, which is vital for the appropriate risk management of their businesses in Asia Pacific. In order to achieve international alignment, the group strongly supports the HKMA and SFC developing an appropriate and proportionate scope for Hong Kong's OTC derivatives regulations and a recognition process for equivalent foreign regulatory regimes. Reciprocal access and recognition will be key to ensuring that Hong Kong's regulatory framework for OTC derivatives is consistent with that of other jurisdictions, so that Hong Kong's financial markets can continue to thrive. Finally, as the detailed rules under many jurisdictions are still in the process of development, we urge the HKMA and SFC to remain flexible and to conduct regular market consultations with stakeholders who will be happy to assist during the rulemaking process in order to ensure that unnecessary disruption of the Hong Kong market is avoided and so that Hong Kong can have the best rules for the continued stability and success of Hong Kong's markets. Thank you.
Next, Mr. Raymond Lee of the Civic Party. In 2008, it has exposed the structural flaws of the OTC derivative market. The Civic Party advocates more regulations on the market. This is a result of the Frank Wall Street Reform and Consumer Protection Act and also the Capital Requirement Directive of Europe. Well, this bill aims at enhancing regulation and to reduce the risk exposed. And there will be mandatory clearing, reporting. The administration at this stage, it says that this only involves interest rate swaps and also non-deliverable forwards. And we asked the administration whether they will consider expanding their scope to include other products in the derivative market, OTC. On the other hand, the bill in relation to protection on individual investors and also institutional investors are lacking. It only says that there will be a registration system for intermediaries. The specific party is concerned because there are many different forms of financial products in the market. You can't rule out the possibility that such OTC derivative products will become popular that can be purchased by individual investors, but they are very complex, and you cannot simply digest all the information in just a few minutes. This may be another Lehman Brothers. The U.S. Dodd-Frank Wall Street Reform and Consumer Protection Act, Subsidiary 9. Subtitle A states clearly that any investment products, including derivatives, the seller will have to, in the process of sale, clearly explain to investors of risks, costs, and conflict of interest involved. The conversation will have to be recorded. The regulators are allowed to, on a random basis, conduct tests on investors to ensure that their rights are protected. Will the administration consider adopting a similar approach so that a financial market can continue to develop while protecting consumer interests? Next, Mr. Timothy Low of CME Group.
I'd like to thank the Bills Committee on the Securities and Futures Amendment Bill for the opportunity to speak. CME Group would like to take the opportunity today to speak about two matters. The first being the absence of transitional and equivalency provisions in respect of new ATS authorization requirements and the new mandatory clearing and trading requirements. I will speak more about this in a moment, but CME Group is concerned that as presently drafted, the bill may have a chilling effect on the availability of risk management tools in Hong Kong. The second matter the CME Group would like to speak about is the statutory insolvency protections. Statutory insolvency protection is important both to users and operators of clearing systems because it provides simple certainty. In the absence of such protection, operators and users of clearing systems must rely upon a complex and evolving set of common law principles. The bill recognizes the need for simple certainty and extends statutory insolvency protection to certain clearing systems for OTC derivatives. However, it extends statutory insolvency protection only to a subset of clearing systems. Clearing systems in the form of ATS must be designated and furthermore must be specified by the SFC to benefit from this protection. All clearing systems pose systemic risks and should benefit from statutory insolvency protection, even if they are not designated by the SFC as a CCP and even if they have not been specified by the SFC as a designated CCP entitled to such protection. I turn then to the absence of transitional and equivalency provisions. When the bill comes into operation, no one will be authorized to provide electronic trading and clearing services in respect of OTC derivatives. Similarly, after the bill comes into operation, no one will be designated to clear or trade classes of derivatives which, over time, may become subject to mandatory clearing or trading obligations. The absence of transitional provisions means that no one can safely offer trading and clearing services in Hong Kong in respect of OTC derivatives. Anyone who carries on a business of offering such a service locally in Hong Kong runs the risk that that business will come to an end abruptly because the service in question is not authorized or designated at the time the authorization requirement or a mandatory obligation comes into operation. This is a real deterrent to offering such services locally in Hong Kong. Separately, the bill contains no provisions by which credible operators of trading and clearing systems outside of Hong Kong may be authorized as ATS or designated as CCPs in Hong Kong on a fast-track basis. Such recognition is important because OTC derivatives trading occurs on a global cross-border basis. First, it is not desirable for traders of OTC derivatives to work with entirely different trading and clearing systems in different jurisdictions. Subjecting operators of trading and clearing systems to requirements in Hong Kong different than those imposed internationally discourages those operators from making their system available in Hong Kong and discourages the use of Hong Kong as a trading and clearing center. Secondly, fast-track authorization and designation will likely increase the number of trading and clearing systems available in Hong Kong. This in turn will mean more options for risk reduction at a lower cost, particularly for local Hong Kong financial intermediaries. Thirdly, fast-track authorization and designation will reduce conflicts between requirements of different jurisdictions. Many of the organizations which have made submissions have already alluded to the risk of conflicting mandatory clearing and trading obligations in different jurisdictions. Fast-track authorization and designation will likely increase the number of global systems available to meet these mandatory obligations. This in turn will decrease the risk that traders will be unable to meet mandatory obligations because these obligations require clearing or trading through different systems in different jurisdictions. Thank you very much.
下一位係香港財資經紀商協。
Next, Hong Kong Inter-Dealer Brokers Association, Mr. Dennis Zhang.
I'm here. We only have one very small point to make. We are basically supportive of the bill. We feel that Hong Kong should regulate derivatives, but a little problem we have got is the choice of derivative. Under the present net, the choice is very, very wide. It covers all derivatives. We feel that certain derivatives are not suitable to be traded on a central exchange. Unfortunately, one of the product that is put on first is the NDF. Now, NDF trading is not just a derivative. NDF trading is basically trading in currencies that have got exchange control. This is very politically sensitive currencies, and we feel that this is not suitable to be traded on a central exchange. I think that is the only point we need to make.
Okay, thank you.
Next, we invite the administration to give us a preliminary response. Thank you. I'm glad to have the opportunity to exchange views with deputations. We are now amending the Securities and Futures Ordinance to implement relevant regulations of Group 20. In the past 2 years, the two regulators have conducted public consultation. The views expressed are in line with what we have in mind. In other words, whether it is over the counter or inside the market, there is a general view to support implementation of legislation to implement the regulations of G20. I hear that in general there is no different view. The second view I've heard is in relation to regulation in terms of domestic legislation. How can it be? What is the best way to do it? It involves two stages. First, the general principle. The framework will be materialized in the principal legislation. Currently, we are consulting the panel, the Bills Committee. This actually is a major project. It involves a lot of details covering many different areas. We're happy to hear from market participants that in relation to subsidiary legislation, market participants will continue to give their views and participate. I heard from deputations that in relation to working out the details of subsidiary legislation, they would like to have sufficient consultation, and given and that the administration will take time to digest the views expressed. Together with the Hong Kong MA, undertake that when we're working on the subsidiary legislation, we will conduct public consultation. There are also views that there should be a buffer period for the market to put in place measures to meet the requirements. Of course, we will legislate to meet the requirements of the Financial Stability Board and G20. And we also keep in mind that it should not impose unproportional implementation or compliant cost. there is a transition period for making arrangements of application of licenses. There are deputations that mention about starting with major financial corporations. In terms of reporting, that can be the general approach. The Hong Kong MA previously asked authorized institutions and banks to start the work first. It's got a sense of pilot basis so that we can see whether they will encounter any problems. And we can also tell whether the approach we have in mind will work or not, and whether it is the most suitable one. And in relation to technicalities, deputations expressed concern about the ATS, the recognition, and also alignment with international practice. I would defer to the SFC and the Hong Kong MA to share with you their views. I've heard from deputations about certain issues that are also of concern to us. It is in relation to protection of investors. Yes, this stems from protection of investors, but in the bill, you may not see the level covering investor protection. When we regulate OTC derivative transactions, and when there is enhanced transparency, risk management and control in the financial market will improve. Well, without such regulations, market participants will not be protected at all, and it's something they don't want to see. There are already provisions under the SFO in relation to protection of retail sale of financial products. When a financial product is put on sale for the general public, offers are made for the market, for the public to participate. They will have to obtain authorization from the SFC. This involves a disclosure risk. They will have to go through the SFC to obtain approval.
Since the financial tsunami, with regard to investment products sold by banks and other financial institutions, the requirement of recording and also measuring the risk level with the investors' knowledge about risk and investment products. Such requirements have been enhanced, and we will not relax in this regard. With regard to OTC derivatives, generally speaking, they are for institutional investors. The majority of them are institutional investors. Well, if OTC derivatives are sold to the public, then they will certainly be regulated by the law. If the chairman permits, I'll ask the SFC, Mr. Lui of SFC, to respond first. And then I'll open the floor. Thank you, Chairman. And I thank you those from the market to give their views. And there are quite a lot of them. And those said by the deputation have been considered by us. The OTC derivatives market is an international market. Hong Kong is an international financial center. The rules we set have to be in line with those of the world. There are different rules and laws in different parts of the world, and they are not the same, say, between European Union and the United States. We are now trying to find a suitable balance so that financial institutions in Asia can meet the requirements of international standards. As a protection of investors, the products at present are for institutional investors. In the future, if there are retail products of this kind, then in promoting and selling such derivative products, they will have to comply with the law, in particular after the Lehman Brothers incidents. There is nothing lacking in comparison with other countries. As for the suggestion that time should be given to the markets to prepare for this, of course, we'll keep it in view. If the market is not ready, then it will be difficult to implement. Thank you. Mr. Lee of the HKMA, just one or two quick points concerning protection of investors. Concerning Dodd-Frank, there is protection. In comparison with that, we are just dealing with the institutional investors, and as for the retail investors, there are other rules. It doesn't mean that there is no rule at all. But this time, we are dealing with the major players. As for working together with overseas regulatory authorities, we are doing that all the time. The HKMA and the SFC have been keeping in touch with overseas regulators. We hope that the implementation will be smooth, and we'll try to reduce as much conflict as possible. Members, do you have any questions for the deputations or for the administration? Mr. Leung.
Many of the participants mentioned about the importance of alignment of this piece of legislation with international requirement. I just want to have a more detailed picture of this statement. In your view, can you tell me whether you think this piece of legislation has been in line with international requirement, or if not, then in what specific areas do you think the bill needs to be changed in order to align itself more properly with the EU or the US requirements? Thank you, Chair.
Who would like to would like to answer the question? Who would like to answer Mr. Leung's question?
Sure. Thank you, Mr. Leung. In our view, the bill is consistent with international standards at present. It presents a framework bill which represents a lot of work that the SFC and HKMA have done with the market and international regulators. So in future, the subsidiary legislation that would be passed by SFC and HKMA, we expect will have a similar level of market consultation and consideration of international markets. And so my understanding is the market does not have a concern at this stage that the MA and SSC and the government will pass appropriate subsidiary legislation for international alignment.
Mr. Leung, if I may ask a follow-up question for the Bureau. Well, can the Bureau explain to us the following? In this bill, there are new licensing requirements. Can you tell us what sort of licenses are they and what requirements are they? So who would like to answer the question? Ms. Yan? Concerning the regulation on OTC derivatives, the SFC has proposed 2 new licenses. new type 11RA. That is in respect of giving advice to the transaction, advising and dealing. The second type is a new type 12RA, clearing agent. If one provides clearing agent service for OTC derivatives and also providing clearing service through the central counterparty, then the institution will have to apply for a license. These are the two new licenses arising from the bill. At present, under the SFC, there are two types of licenses. With the inclusion of OTC derivatives, the licensees may have to expand their service if their business is not to be affected. Now, these two licenses are Type 7 ATS. ATS at present does not include using the ATS for OTC derivatives transactions. The second type of license that will be expanded is Type 9, provision of asset management service. Our proposal is to widen the scope of the license so that it can cover OTC derivatives transactions in respect of portfolio management. Perhaps Rico can supplement. Yes, Mr. Leung. I think Ms. Yan has already highlighted this point, if I may say a little bit more, concerning Type 11 regulated activity. We want to add that because we want to regulate those intermediaries who will provide transaction service to their clients. They need to get a license from us. That is similar to Type 1 and Type 2 licenses under the SFO. Under the SFO, Type 1 and Type 2 licenses regulates those involved in securities. In the future, we will include derivatives, OTC derivatives. As for the other type, it is for clearing service. We require mandatory clearing for OTC derivatives. They have to be cleared in a designated clearinghouse. And some financial institutions may provide a clearing service. If they provide a clearing service, they will have to deal with assets of their clients, and there is also the question of threshold. As for 7 and 9, Ms. Yan has already spoken on them, and I'm not going to repeat. Mr. Leung, I still have one more question. I'm a bit worried. The SFO was first implemented a decade or so ago. There are 8 or 9 licenses, and now they propose to add it to increase it to 12. If you continue to widen your scope of regulation, then in the future you may end up with 16 or 17 licenses, and each licensee of a type of license is just limited to a very small scope of business, and that will not be favorable to SMEs in particular. A firm may have to get 6 or 7 kinds of licenses in order to do business. Concerning, would you say widen the scope of the licenses so that there are not too many licenses? And under what circumstances and by what criteria you decide to issue a new kind of license? Mr. Lawyer. Now, Mr. Leung said that since the start of the SFO, there were 9 kinds of licenses, and they have been there over the years, and they are applicable to the ordinary securities market. And we've added 10, 11, and 12 because of the 2008 financial crisis. The regulatory regimes of the regulatory authorities of the world have conducted a review on the regulatory regimes, and they deal with credit rating agencies. They are not they are not general market participants. They are very special institutions. I'm referring to Type 10. As for Type 11 and 12, they are to regulate large financial institutions using financial instruments to deal with their business. As for SMEs, fund managers, they may not need Type 11 or Type 12. They are rather special. In terms of systemic risks, we believe that they are worth regulating.
Mr. Lee. Well, first of all, I welcome Deputations for coming here today. I've heard your views in general. You support the bill, and you support aligning Hong Kong's requirements with that of the international arena. And you identify with the general direction of the bill. Do you have any specific requirements when it comes to details, and do you think you encounter certain difficulties? And if you have in mind any of the difficulties, please let the SFC or the Hong Kong MA know so that they will work on it. Anyone who have questions to ask? When they spoke, they have already spoken on what they would like. I believe that they will have detailed discussions with the administration. Who would like to respond now? Mr. Jim. Well, the general framework is in order. What we're concerned is implementation. First, cost. There are lots of systemic matters involved. So we wonder whether they will be taken up by major banks. The Hong Kong MA said that that has already been done. Well, financial transactions may not take place in Hong Kong. If the cost is too high, they can go somewhere else. We may not use Hong Kong as the booking entity. If you require financial institutions to report or to declare the transaction entities, then we may encounter difficulties. How can you ensure that they report, they make an accurate report? You have to work with us to work that out. Some people mentioned that certain derivatives may not be suitable in the trading of exchanges. That is the NDF, the non-deliverable forwards. When it comes to regulation of OTC derivatives, it's very complicated. So if you want to cover many different types of derivatives, I think you need to talk to the industry and implement it by stages, so that we can work on cost control and while maintaining Hong Kong's competitiveness. And that's all I want to say. Mr. Low.
Is that we don't have any subsidiary legislation. And so we have framework legislation right now, but we don't have any idea what is going to happen. I think that there's some consultation discussion about what will happen with the subsidiary legislation, but there is a considerable amount of uncertainty because we actually don't know how the provisions will be enacted or introduced by the SFC down the line. So for many of the concerns which I think many of the organizations today which have been submitting, it's not clear how those will be resolved. So for example, with CME Group, transitional and equivalency provisions, those may or may not be incorporated into subsidiary legislation. And the concern would be, are they? And if they are, how are they done? There's no guidance given in the legislation whatsoever as to how any of these are done. In relation to alignment with international regulatory initiatives, again, there's discussion from the regulators that this will be done in an internationally consistent way. And there's nothing in the legislation right now which is inconsistent with international regulation. But then again, there's nothing in the legislation which is specifically consistent with international regulation either. We just don't have the details. And I think that many organizations probably have the same concern, which is that there's a lot of uncertainty with this bill being passed with just framework legislation in place.
Anything to add, Ms. Lee? I would like to hear from the administration about the issues put forward by deputations. Well, in general, they are concerned because there is at this stage no subsidiary legislation, so they wonder what the details will be. When will you start consultation? It is a valid point. They would like to know more about the implementation details and more details of the subsidiary legislation so that you will have an idea about the implementation requirements and whether they are in line with international practice. We fully understand that. And we are also aware about the duplications or the differences with international practice, and this has in turn created difficulties. We understand that, and we're also concerned. Hopefully, before the end of this year, the two regulators will conduct consultation on draft subsidiary legislation so that the industry will be able to see some details. We encourage regulators to start discussions about how to draft the subleg. Deputations talk about compliance cost. Where there are new requirements, undoubtedly, there will be cost implications. We hope this will be the cost implication will be reasonable and feasible. The International Bank of Settlement was looking into the cost and benefit to find out what the situation is. They think the finding is that this will be beneficial to global productivity. In other words, when it comes to collaterals, liquidity, there may be additional requirements, incurring additional cost. This will improve the operation of the financial market in the end. So it is, as a whole, beneficial. When it comes to Hong Kong's competitiveness, this is an international requirement. If we do not do it, it will have an impact on Hong Kong's status as an international financial center. You don't want Hong Kong to be put in a disadvantageous position. You want to align the practice so that everyone is competing on a level playing field. Who would like to supplement? About implementation details, just like what Ms. Yan said, we will conduct a consultation hopefully within this year. But before the consultations starts, we will take into will draw reference from the views expressed today and over this period, and we will also maintain contact with representatives of the industry. We will do our best to incorporate and to take reference from all views expressed. Well, the administration said that that will be before the end of this year, when they have further discussion with you about details of the subsidiary legislation. So you're most welcome to submit your views. Mr. Chen Kim-po. I thank deputations for coming, and the majority of them support the bill. It's very rare that we see such strong support from the industry, because mostly they object to it. Yes, there will be compliance cost, and I'm very concerned that the administration will overregulate our financial market after Lehman Brothers, thereby dampening our competitiveness. We see that in the US, Australia, EU, and Singapore, they have all done something. And I think that is one of the reasons why you find that acceptable. Well, we see some major corporations here, but what about smaller operators? Well, have they told us all their concerns? Well, we see that there will be consultation and there will be implementation by stages. What about medium-sized organizations? Have you received any objections that you have not mentioned to us? Can you tell us more about it? Or requests to further improve it? Ms. Yan. Of course, we cover organizations of all sizes in our consultation. When it comes to OTC derivative transactions or activities, most of the participants are large corporations, but it doesn't mean that we do not attach importance on smaller size organizations. We have not heard any particularly huge concern. That we've heard concern. We've heard views about cost and facilitation measures in the licensing regime. Of course, we have to weigh things up when it comes to adding types of licenses. We have to strike a balance. Say, for example, if new activities can be grouped under existing licenses, the regulators may not incline to add more types. But if the newly regulated activities cannot be covered by the existing types of license, they may consider adding to the types of licenses. And we fully understand that we should not keep changing things, because the industry will find it difficult to keep up. So there are two new types, because we have no other alternatives. We have to add types 11 and 12. And where there are existing types that can be expanded, say for example, type 7 and 9, we expand the coverage. Whether it's the bill or the future subsidiary legislation, we keep an open mind to take on board different views. Anything to add? No? Deputy Chairman. I'd like to say something about SMEs. A lot of the products are not sold in some exchanges. They don't have a full understanding of the requirements, but I'm happy to hear that deputations agree to enhance regulation to protect consumers or investors. I have a question. Well, in relation to the IIS and the NDF, what about data related to these two types? Data with the administration, because they are of a great reference value. How do they ensure fair disclosure of interests? When it comes to disclosure, I would defer to Hong Kong MA. In relation to designated products being regulated, we will conduct consultation. In the bill, there is a definition of OTC derivatives. It's a rather wide definition. In the process of implementation, we will consult the market about particular products. This is the general direction, the general approach. And I will defer to Mr. Lee. Yes, in relation to data, transactions, it is market-sensitive information. In this bill, the data is directly given to the Hong Kong MA, who will have custody of the information. The Hong Kong MA will handle such information very carefully. There is a requirement in the international arena about handling of such information that it will have a certain degree of transparency. Information dissemination will have to be fair so that everyone will get the information at the same time. We will make an announcement later about the details. And we will also liaise with the industry before we proceed. We'll be very careful. Anything to follow up on? No. Members, any other questions? Mr. Kenneth Leung. Type 12, settlement system. My first question is directed at the SFC or the administration. Under the bill, the capital and liquidity requirements of this type, what is it? Are there other requirements?
Mr. Lui of the SFC, concerning Type 2 license, the clearing agent license, it is a regulated activity. The operator has to meet certain capital requirement. At present, the specific details will be provided for in the future financial services requirement. And we will consult the market and seek their views. So you have not made up your mind yet. Now you say that the clearing agent license will mainly be held by financial institutions. I therefore want to ask representatives of the market concerning the market participants. Do they like 2 or 3 big clearing system, or a single clearing system, or many more clearing systems? Who would like to answer the question? I don't believe there will be too many. Oh, yes. Mr. Jim. For Hong Kong dollar, the clearing system is CMU, and is highly recognized within the market. Our concern is the credit risk of the system. if the clearing system is provided by an external body other than the government, and then how can you control this? And the next is the cost for using the system. Well, this is my personal view in this regard. We believe that we may not like too many such systems. According to the two overriding principles, I think implementation can be made according to these overriding principles. The majority are participants. As for building up and developing the system and maintaining the system, would that be given to the market, or would that be done by the market? I think, or by the government? I think further discussion has to be made. Is there any established policy concerning Type 12 license? Is it a tailor-made license for C-cars, or do you have other systems in your mind, or do you only have C-cars in your mind? Mr. Lui. Type 12 license is a member of a clearinghouse. C-cars is a CCP, a clearinghouse. The clearinghouse will invite clearing members. Type 12 license is for anybody who wants to be a clearinghouse member or a clearing system member. It is a kind of service. As for C-cars, it's a CCP. The SFC has the power to approve it and has the power to enable it to be set up. There is an empowering provision to be given to the HKMA and the SFC. Now, it is a license for settlement participants, but who is going to operate the system? Say for OTC derivatives, say a client wants to do an interest rate swap, IRS, and if it is required to have mandatory clearing, then the service provider will have to consider where should he go to do the clearing. He has a choice. Now the HKEX is now applying for an OTC clearing service. That is one choice. The dealer can also go to an overseas clearinghouse or CCP to do that. And we allow the SFC to recognize overseas CCPs, which complies with international requirements. So those who have Type 2 license can go to do clearing on behalf of their clients overseas or locally. Okay, I still have one more question, Mr. Chairman. Say, an ordinary business concern deals with derivatives, OTC derivatives. It may only deals 4 or 5 transactions a year. It is just a big multinational corporation. Does it need to get a license? Well, if they are regulated persons, including the licensed institutions under the SFC or the AIs, if they do any OTC derivatives transactions, whatever amount it is, it has to comply with the reporting and clearing requirements. But if they are not regulated persons, when they participate in OTC derivatives dealings, they will, when their dealings meet a certain threshold, they will have to subject to the regulation. As for SIPs, they are of a higher level, when they reach a high threshold, they will also have to register with the regulatory bodies so that they may be subject to a certain level of supervision. Can you be more specific? If just a company deals 2 or 3 transactions a year, does it need to be registered? Mr. Lawyer. Well, it doesn't say one deal or one transaction or how many transactions. If a big institution needs these products to hedge their risks, if it deals with a certain bank and the transaction amount reach a certain level, then there must be mandatory clearing. Okay, it's very clear. If members do not have further questions, I would like to thank the groups and also representatives for attending the meeting. You may excuse yourselves, and we will continue to deal with other aspects of the bill. Thank you very much for coming.
嗱，跟住咧，我哋就要即係睇睇大家同事咧對於。
Well, I'd like to see if members have any question concerning the policy aspects and also the technical aspects. Yes, thank you. Mr. Leung, Ms. Kenneth Leung, concerning Part 5, the amendment to the disgorgement order. In Part 5, it seems that it is not related to the regulation of OTC derivatives. Why suddenly you add them in? And what will be the implications of your amendments? It seems that it is rather serious. It is also related to the OSCO. Can you explain it to me why it's so serious? We want to take this opportunity to make certain amendments. These amendments touch on the SFO. Now, under other circumstances, when these provisions are breached, then under the OSCO, such behavior, such offences would be caught, and the illegal gains would be confiscated. But under the present arrangement, since even if there is such an offence, if the offence is not grouped under the OSCO, then the court cannot confiscate the ill-gotten gains. In terms of the deterrent effect of the law, in particular in respect of money laundering, this is a very important aspect. We'd like to take this opportunity to plug this loophole. If there is market misconduct leading to ill-gotten gains, then such ill-gotten gains can be confiscated by the court. Can you explain to me what you mean? Is it just limited to the benefits gained through the market misconduct? Do you have a cap on the amount of money to be confiscated? Yes, there is. If I may turn to the relevant provision.
What?
Maybe I will provide information after the meeting. Yes, I think it is covered in the law. Do members have other questions? The Vice Chairman, any questions? If members don't have questions on the policy aspects and technical aspects of the bill, then let me tell you that we have earmarked 5 sessions for the Bills Committee, and the Secretary has informed you of the 5 dates. And they are 28th of October, 15th of October, 2:30 p.m. And afterwards, there are 5 time slots earmarked, and they are 28th of October, 10:45 a.m., 12 November, 10:45 a.m., 22nd November, 10:45 a.m., 10th December, 2:30 p.m., and 20th of December, 8:30 a.m. This is just a preliminary timetable. If members have further questions, well, we have more time today. But if we don't have other questions, then at the next meeting we'll go into clause-by-clause study of the bill. Do members have any views? Mr. Leung, do you have any view on that? Okay, then at the next meeting we will go into clause-by-clause study of the bill. And during the clause-by-clause study, if you have any questions concerning policy and technical matters, you can still raise your questions. So we call it a day. Thank you very much. Thank you.